So I want to cover something also regarding retirement planning, which is from the inheritance law. We're talking about paragraph 115 of the inheritance law. I'll read it out loud, and then later on I'll, give the implication that it has. The residential apartment. In an apartment in which the testator was the owner on the eve of his death and lived, the heirs, his spouse, his children, parents, who were living there at the time with the testator, may continue to live there as tenants of the heirs to whom the apartment fell. The rent, its periods and conditions will be determined by agreement between those remaining in the apartment and those heirs, and in the absence of an agreement between them, by the court. The court may determine, at the request of said heirs, only those who do not have another apartment to live in should continue to live in the apartment. 2. That those remaining in the apartment will continue to live in only part of the apartment, provided that this apartment includes the kitchen and utility room, if any. So, I mean, it's actually very interesting, because I guess there's some, without saying it, you have some kind of a compensation toward the people who lived with the elderly, and usually, they help out. May it be because they have a sickness, terminally ill, they're there, they give support, medical support or emotional support to their parents. It's usually a relationship like that. So it's interesting that there is like a compensation by the court itself, which means that, if you have an heir which wasn't kind or was abusive towards the parents, and he has a lot of power, that person cannot evict. They cannot do a request to court. It has no ground to ask for an eviction, just an eviction. He can ask the court to give a rent, which makes sense, that the court will decide the rent that should be paid. But he cannot, evict and do a one-sided case towards the people who took care of the elderly parents and gave them medical care and help and support and assistance and so on and so forth. So it's a very interesting that it's in the law itself. It also gives if you talk about planning, retirement planning and so on, it if you want to avoid later on the taxation of sale of a house and so forth, it gives some kind of a planning scheme in that meaning. And also, for it also, I'm not continuing, I do not continue to read, because it also goes on a lease. But this lease only talks about 25 years. But you have a situation where if you had a lease and it wasn't owned by the parent who died, but it had a long time lease, the court will protect you. But it's a long time lease. The court would protect you. The owners, which are not the family, the owners who rented it out, cannot evict you, but rather can ask you, you go into the shoes of your parent because you were there in the time of the death. It gives you a privilege. So you had a lease, it's not, cancelled, but it goes forward into your hands later on, and you continue to live in it. But it's not, there are situations like that. I mean, it's very prominent in the UK and Ireland and Holland, where you have long-term leases which are for 25 years, where you have a government house, or you have a but in Israel, you usually have rent per year, and you don't make with a private person 25 years forward with checks and everything. It just doesn't happen a lot. But there is defense by not by rule, but by law itself, by the Israeli law.